Before even I start about navigating the objections and the oppositions in the trademark, I'll just take 2 minutes just to share what is trademark so that we can just directly link it with the objections and the oppositions, right? Now, definitely, there are no business as on date. If you ask me, there are no business who doesn't value IPR, and if they don't value IPR, they are not able to do the business. Okay? So basically, today at this particular juncture, I can be, I'm right to say that IPR is the ingredient, basic and the most important ingredient for any business to progress. So the moment I say that, it means that you cannot avoid IPR in your business, or you should not even avoid, or let me put this thing that the moment you think of any idea or business model, the first thing you have to think when your model is complete is all about the brand. It's all about the name which you want to give. Now, IPR is very big. It includes trademark, copyright, patent, geographical indications, patent, design, etc., etc. Right now, let me concentrate on trademark as on date. Out of all, there's no doubt that every IPR branch is very important because सबको हम साथ लेके चलेंगे, then only the nation or an individual progress in particular field. Trademark जो होता है, trademark, this is the biggest commercial point of view में, this is the most popular among business in India, right? So the moment you see any name or device, the first thing which comes is trademark. बहुत सारे लोगों को शायद ये पता, whenever they see any symbol, they say trademark. So trademark is a part of your business. Now, definitely, there's a process through which you file your trademark. I will just read out that process in hardly 30 seconds. If possible, just listen to it. The day you finalize your particular word or device, whatever the word is, you will go to the IP database of India or any other country where you want to or you plan to. I'm talking about India as of now. You will search whether the mark is available or not. Now, the mark has to be very clear. I don't know if I'm saying very clear, it comes with very adverbs and adjectives and nouns. Okay, so the moment I say that the mark has to be very clear, it means it should not have any reason to be objected by trademark office or opposition by any third party, because this is where एक नींव होता है, this is where you decide whether your mark is good or bad. So basically, if you ask me, your mark has to be original. Go for an originality. It has to be relevant in the market, and definitely from the branding point of view, marketing point of view, it has to have an appeal, right? Now, I'll come to that particular marks which had an originality, but it never had an appeal. Relevance hoga, it never had an originality. There are secondary markets in pharma where you will find the nearby Lakta Bukta copied mark. That's a different, state of doing the business. So your mark आप file करते हो, the moment you file the mark under appropriate classes, there are around 45 classes. 1 to, I will say 34 is the manufacturing classes, 35 to 45 is the service classes. For me, 35 is the biggest major commercial classes, because 35, I always believe that 35 is something that all the marks, whether you register from 1 to 34 or 36 to 45, it has to come in 35, because we are more of a service oriented business providers nowadays in India. So that becomes 1 to 34, 35 and 36 to 45. आप register कर दोगे, definitely your registration में जाएगा. Trademark office will figure out whether this mark is original or not. If they feel that this mark has some issue, they will raise an objection. Now, what is an objection? I'll come. Then definitely if there is no objection, it will be advertised in the market for 4 months. If there is no opposition, your mark will be registered. Now, this process as on date is not taking less than 6 months, but I'm on an average, it takes around 1 year for you to get the registration certificate. Now, the issue comes when your trademark is objected. Now, the question comes, why it is objected? What is the reason behind this objection? So there are many reasons out of it, many reasons. There are only 2 sections which deals with the objection and no doubt opposition also. But this 2 section is basically the core of trademark law. Core, I mean to say, you should know as a trademark lawyer or as a business person or as an in-house counsel. one has to be aware what is section 9 and what is section 11. This two section is the only reason why objection will come and most probably opposition will come. In fact, I'm using the word mostly because it can be here and there something very unique may come, but this is the two sections which deals with the trademark law when it comes to any issues, infringement or passing of suits or action. Now, if objection comes, you need to reply. Definitely, you need to reply within a month. आप reply करोगे. If they are happy with your reply, they may pass an order for the advertisement or they may call you for a hearing. Mostly it becomes a hearing part because you need to explain to them why your mark is good, why the reason objection was made is not good. If your hearing gets a very positive part, your mark will be advertised. If not, it will be refused. If it is refused, you have to go to the High Court. Definitely because the IPAB has been repealed. Objections आता क्यों है? This is where now I need to get into this particular part. So basically today we will cover how to take care of the objection and then opposition. Opposition ka procedure I will tell you later when I just come to that opposition part. Now what exactly the opposition is? In brief, if your mark is similar, the word is very important, similar. I'm not connecting all the mark, but I'm just saying similar. ठीक है, identical होता है, nearby होता है. I'm using the word similar. If it is similar in appearance, in sound, in meaning, in lookout, objection will come. I will give out some examples कि किस तरीके से होता है. ठीक है. I will also read out section 9 in a very brief way so that theory doesn't become the part of this lecture. So if your mark is already there in the market, if your mark is a nearby version of the well-known mark, if your mark is very much associated with any of the well-known names in the market, if your mark is somewhere not as per the procedure of the law, if your mark falls under the category which is not even allowing you to go for the mark, then definitely your mark will be objected. Okay. Now this section 9, I'm just opening the section 9 from my, okay. Now this absolute ground for refusal of registration, this is very important because I'll show the objection how it comes, which are devoid of any distinctive character that is not capable of distinguishing, which consists exclusively of marks indication to designate the kind and quality, and which has become a customary part. Okay, so this should not be registered. So right now I will just complete कि ये होता क्या है, तीनों का meaning कैसे बैठता है. Suppose if your mark, I am talking about section 9(1). Suppose if your mark, okay, if your mark, whatever the mark you have, it fails to distinguish the goods. ठीक है, आप कोई भी मार्क लेते हो, if you are not able to prove how your mark distinguish, किस तरीके से distinguish करता है from another, it is deemed to be non-distinctive. This is the section 9(1) वाला फंडा होता है. आपके मार्क को इतना अच्छा होना चाहिए कि वो distinguish करना आना चाहिए. It should have that feature. If not, then definitely the objection will come under section 1A. And then how will you reply? Just for an example, I'll share. There's a very famous case when one of the company, he wanted to go for the word Simla, Simla, not Shimla, Simla. Now they had a very different innovative idea saying that why Simla is good for my product and why it is not, why it is a distinguished feature. And at the end of the day, they came to the conclusion that Simla cannot be registered because it is, first of all, it is not distinguishing your goods or services from any other thing. But the most important part came into picture was section 9B. That already there is a name in the market. And this is where one particular mark was rejected. So the moment I am saying that your mark will fall under 19(1)A and B, remember the objection doesn't always come for specific 9(1)A, B or C. It will always come if you have to comply with 9(1)A, B and C. You cannot say कि मैंने A comply कर दिया, B रह गया. No, you have to comply with one section 9(1)A, B and C. So definitely it has to be distinguished. सब distinguished होना चाहिए. There is one mark in the market. I will ask this question whether it is right or wrong, but right now let me say that there is a garment mark which is known as a Bewakuf. Bewakuf. It's a very known brand in South also. Now, You may say that Bewakoof is a very good brand. There is no doubt. It has become a very good trend among the generations, younger generations. Now, Bewakoof को नॉर्थ में हम idiot बोलते हैं, but फिर भी वो मार्क है उनके पास. They are the owner of this mark and it is doing very well. Now, there's a query from my end to anyone if you can answer in the chat box or not, whether Bewakoof falls under section 9(1)(a), B, or C, or some other section, section 9(2) also, and whether this mark should have been registered or not. My view is that Bewakoof has nothing to do with the goods or services. They just came with an innovative word. They might have felt this is an innovative word, but जो north में रहते हैं, they know कि Bewakoof is a very household common name. Bewakoof, pagal, idiot sort of. So they came with the name for the garment industry, and definitely they were able to get the trademark. So they were able to distinguish the mark. And that's why even the objection came, I am pretty much sure it came, and then definitely they had their own reply to it, that why Bewakoof doesn't fall under this particular sections, and they were able to get the mark. They were not able to get the mark of late, if I still remember, in Bombay, because in Bombay it's very common to say anyone Bewakoof in a lighter note also. Some might take in a very bad way, but on a lighter note, yes, Bewakoof is a very common word, generic हो जाता है Bombay में, because anyone who is from Bombay will know कि Bewakoof का importance क्या है, and it's a daily routine word. So definitely you need to have a very distinctive mark. It has to be very original. It has to be very different. Now another feature, most of the objection which falls is like this. Descriptive nature. You need to, आपका जो mark होता है, it has to be very different. थोड़ा characteristics अलग होना चाहिए. You are able to define the character in such a way that nobody will come to your nearby mark. और इसका सबसे बड़ा example I'll tell you is that there was a case from Hindustan Development Corporation. They wanted the mark Rasoi, ठीक है, Rasoi, RASOI, for definitely for their oil products and everything. It was refused on the ground that Rasoi is a very generic name in all the households. So they were not able to define, they were not able to distinguish, neither they were able to produce, neither they were able to give any further characteristics of that particular mark, and hence it was refused. Remember why I'm saying this, that each and every word, because when you draft a reply, your reply has to be in a manner that it covers, or I will say it satisfies all the sections of definitely what they objected, but all the sections of 9(1) A, B, C. Because your mark has to be in such a way that you are able to comply with all subsections. Your reply will become the evidence when you argue the matter on this objection. And suppose if your mark is refused, definitely they will give the reasons for the refusal. Then if you go for an appeal, your reply will become the evidence. Then you cannot modify your reply and say that no, I never meant this, I always wanted this. Because when they refuse your mark, they refuse the mark based on your reply, what you find. So this is where you or me also, when you draft the reply, you should know what sentences to be used, what interpretation you have to make, and all this you have to make in a manner that suppose if the matter goes to an appeal, or if the mark is opposed, this is the base I am creating a defense in my all the petitions or suits or whatever till my mark is registered. And this is where you need to be very specific when you reply. Objection is not like a suit where you need to write everything. You just need to be very specific on that particular mark. As of now, let me say, okay, I'm just saying one question now. What I want is everyone to answer at a later stage. PCOD. Now, you can figure out what is PCOD. This particular mark was registered, and it is still a registered mark. And they have registered for, if I'm not mistaken, for a women healthcare medicine. My question to all of you, if you can all answer, is whether this mark should have been registered. If yes, why? And if no, why? Do answer if you are able to. So now this is where section 9 this particular comes. And now the last part, C part, which consists exclusively of marks or indication will become customary or current language. Fridge is the best example. Fridge bolte bolte generations chala gaya, and that's why fridge as a word is not being registered for that particular product, and definitely it has its own meaning. So whatever mark, it should not be very generic. It should not be generic. Well, the moment IC should not be generic, there are certain marks which are very generic and it has been registered. But why it has been registered, it has a different reason for it. Like Naukri.com. Even Naukri is a very common word. ऐसा नहीं है कि it only started in 2000. Everyone since decades we have been seeing कि नौकरी मिला क्या, नौकरी है क्या, नौकरी का कुछ होगा क्या, आपके यहाँ पे नौकरी है क्या. So नौकरी is a very common word. But somehow they were able to get this mark. They were also able to win when some of them tried to copy the same similar sort of a mark. How I'll deal with later, but definitely there are certain exceptions. You need, end of the day, trademark hai kya? You need to prove your usage, your practice, what you did, the manner in which you have been able to establish yourself in the market. Trademark यही है. End of the day हम law को side में कर देते. End of the day law is a law, but business is run by trademark can be established by your business practices. The way you do, the way you have incurred expenses, provided it has some logic behind it. That's it. ये तीनों चीज को आपको कवर अप करके somewhere you have to put out. Now what is section 9.2? Section 9.1 ABC is very clear. I'm assuming distinguish होना चाहिए, clear होना चाहिए. 9.2 होता क्या है? 9.2 is like is of such a nature or to deceive the public or cause confusion. Now, let me tell you one live, recent example. One of the Ayurvedic organization, they wanted the mark by the name My Natural. Now, My Natural is just too common. I mean to say, Ayurvedic is always natural. This is what the point is. He went to get the mark. Somehow, this mark was objected. But during objection, the hearing went in such a way that it was accepted, no doubt. And then it was opposed. So now the question comes whether that particular mark, my nature, falls under section 9.2A or not. I want if anyone can answer in chat box. So there was one case where one of the company wanted to file for the mark 100% natural. And definitely it was rejected because it could have caused confusion because end of the day, आप Ayurvedic कर रहे हो, it has to be nature. The moment you say 100% natural, every Ayurvedic becomes natural. That's a different point. If anyone has an issue that कि नहीं आजकल आयुर्वेद में भी ऊपर नीचे होता है, so that's a different perspective. But the moment as a customer, as a layman, if anyone asks me कि आप Ayurvedic लेते हो, I will say हाँ natural दवाई लेता हूँ. But this is what you don't fall under that particular part. Now, second is religious accessibility. जहाँ पे, if you all know, recently what has happened is that there was a mark. अगर आप Google करोगे तो CHUTIYARAM. So this particular mark was registered. Somehow it was registered. Registered in the sense it was somehow it got its registrations out of. And it became a very viral because everyone said, how can you give this name? Because this is hurting Ram, because the word CHUTYA before the Ram is something very bad. It is not a good word even to say from the mouth. So what do you expect from us? And definitely since you're using it with one of the very well-known word like Ram, it is affecting a religious point. And definitely after that particular issue came into the picture, it was revoked. Now my question on that, whether that name was bad, if so, why? If not, why? If you ask me personally, I am not able to figure out why that particular mark was bad. I have my own reasons for it. Definitely the emotions played the particular role when it came to that mark, but I feel that that particular name was a very good mark. If you keep aside everything, there is a very big interpretation when it comes to hurt the religious accessibility because there is no end to this particular word. The moment we say religious susceptibilities, I mean there is no end, but somewhere we have to keep an end and then move on. So if anyone can answer to that, but definitely that mark was rejected on this particular point. ये गलत है. C, when it comes to obscene matter, no doubt it can never be used because you are not allowed to use any name which is bad. You cannot use the name. There was a very famous name, I forgot. Somehow someone was trying to use the mark, which was a very It was a very bad word, and definitely it was rejected. Fourth point is definitely if it is prohibited, like you cannot go for the name emblems and Mahatma Gandhi or Pandit Nehru. Definitely you are not about to do that. Can I read section 9.3 and I'll just complete that particular section? The result from the nature, the shape of the good from the technical result, which is of substantial value. Remember, the shape of the good is also important. The shape of the good is very important because you cannot go for the trademark of a tennis ball which is circle in nature because वो circle ही होने वाला है. So definitely you cannot go to that part. Then definitely your functional aspect, आप design of a screw or a gear आप नहीं कर सकते हो registration, simple है. Now this is where we complete section 9. Now I'll deal with when anyone has a query. This was an absolute ground. Absolute ground बोले तो इसमें you have to be very perfect. You cannot expect anything lesser from anyone. You have to comply with section 9. Section 11 is relative ground. This is where the whole concept changes actually. If you are able to understand what is section 11. Because section 11 gives you the right to at least explain, and they give you the right that yes, my mark is good even though if it is little bit of nearby, but these are the reasons why my mark should be registered. I am not reading this part. The trademark, if its identity is same, the similarity of goods, there exists a likelihood of confusion on the part of the public. Remember section 11 का जो सबसे important keyword है वो यही है likelihood of confusion. That's it. Now, what is likelihood of confusion is in your objection reply, you should devote, if you are writing, 1 page of reply, your 3/4 of a reply should cover, try to make an understanding that my product in no way creates a likelihood of confusion with anything or a similar mark. Section 11 is all about dealing with likelihood of confusion. Now, if that examination report can be open, so basically by the time they start this examination report, this is the examination report. Okay? Now this is the pattern when you get the trademark objection letter. I just want to read how it works out so that then I'll come to the point how to reply also. Trademark have issued this notice. The objection is raised under section 9(1)(a) of the trademark as a common surname, person with geographical indication. And then they are saying that you need to reply. Now, होता कैसा है? Now, this objection was raised because they felt that common surname, personal name, geographical name is similar and hence you are not able to distinguish the goods. So this is one of the way the objection comes into picture. Okay? How to reply? Now, if this particular section comes, this is the way I reply to any objection is like this, that first you need to identify what is your mark. Definitely you might be knowing your mark. Second, you need to explain since when you are using this mark, if you have filed with the prior usage. Suppose if you have filed your application as a proposed mark, then you tell that from the date of the application till this date we are replying as an objection, we have been in this business and we have done the sales of this amount from this particular mark. And now the question comes how you are able to distinguish. Then you need to be very clear that my mark has nothing to do with the common surname. Now suppose if my name is Lalit Jain, my name is Lalit Jain and I have applied for Jain Logistics. Now, if I am a Lalit Jain, there are thousands Jains in the market. Now the question comes whether I am able to get this particular name, Jain Logistics, because Jain is a very common surname. I mean to say, every Marwadi will get a Jain. Every Marwadi. Though Jain is not a surname, Jain is a caste, but Jain has become a surname because whatever is the reason, if I am a Lalit Jain, there is some another Jain. So now the question comes whether I will be able to get the Jain Logistic name or not. My reply will be like this, that since Jain is very common to everyone, I am not claiming my ownership on Jain. I want Jain Logistic. This is my mark. You cannot separate two marks differently and then say this is generic, this is non-generic, or both are generic, so I am not able to give the mark. So your reply has to be that Jain is my surname, no doubt. Even if it is a caste, it is my surname as per my date of birth certificate. So definitely as a Jain, I have a right to at least use my name. Okay, surname. But I am claiming Jain Logistic as a whole mark, not one mark, whole mark. So the moment I am able to prove that, Jain Logistic is the whole mark. My second responsibility comes into picture. Second is whether there is any similar name in the market or not. So there is no name by the name of logistic. But now this is a very important question comes into market that today, if you ask me, the biggest evidence, if at all you feel you want to prove is the Google keywords. You should go to the Google and say Jain Logistic. You may find number of pages or you may not find number of pages, irrespective. If you are able to find there are no similar mark by the name Jain Logistic, there might be Lalit Jain Logistic, there might be Falana Jain Logistic. I'm not saying that. If you are not able to get this two separate mark, now you need to rely on that evidence that even the market doesn't have a similar name which I'm using. Fair enough. If I'm able to prove this, the third point comes into picture is that whether this name will create a confusion in the market. So the answer will be, I will file this mark as a device mark or a logo mark. And now I'm claiming that as a logo mark. Me getting this mark as a word per se is a very little bit dicey issue. Because logistic is also a very common name. Jain as such is a common name. And anybody can use the Jain logistic as a tagline. So now it is on me whether I want to take the risk of running my business by the name Jain Logistic or I want to take the risk by saying Jain Logistic and Company at all. So if you ask me today, if you ask me, suppose if I am in the place of a TM officer, I will deny this mark because I'm not able to get any distinguished feature and definitely both are generic. Even if I take as a whole, it's very generic. But if I'm able to file as a device mark, then definitely I'm able to get this mark because now I have distinguished my mark, which is a logo, from another Jain Logistic or whichever is in the market. So this is where you going for the search report becomes the base on how to file a mark. Okay, suppose you are not able to find out whether you are able to get this mark or not. This is what the normal mindset is. You file as a word per se and you file as a logo also. The moment you get the logo, you can rely this logo on your word per se and then argue on this point that Jain Logistic generic generic hone do, but it is attached to me. The most important point is definitely the risky part that if you are able to generate any revenue, show that I have already earning from this particular, though it is not mandate on them to accept this, but you can create an evidence. Fourth point, suppose if someone is very adamant that he wants this mark, then nowadays what is going on that you will get this as a partnership name. Definitely nowadays even partnership firm, if you go for a mark, they issue the notice that this mark is already in market. That's a different part. Suppose if you're able to get this name on the MCA website, Jain Logistic LLP, then even if you go for a trademark or not, it depends on you because you as such one of an authorization, organization has given you the mark to use it. Yes, there is no doubt there's a provision in the Companies Act that anyone can file for the change of the name on your behalf, provided he is able to prove that he is the owner of the mark. That's a different story. So for me, Jain Logistic, if I'm able to get this objection, file as a logo, I should get the mark because I have created a distinguishing feature, even though it's a surname and sort. This is where I'm able to get this mark. Can I go to the second examination report? Okay, now this is definitely one of the mark which is going on and it came under section 11. आप नीचे चलेंगे थोड़ा, just go down. Okay, just read the objection. What is there? It is open to the objection the relative ground that there is a similar mark or same mark is already there on record. So now I have to prove that there is no likelihood or no similar mark. If you see there are two names which is similar to my mark. The real brand which was filed was Probel, Probel. And what they found is there is already by the name Propel and Propel device. So what they are saying is that your mark is falling under section 11, not under 9, because 9 I have already covered. Somewhere I have taken care of, but I have to cover now section 11, which definitely speaks of likelihood of confusion. So whether my Probel is similar to Propel, I have to reply. I'm leaving it to everyone. If anyone can tell me whether Probel or Profile, whatever is the mark, can I get the mark or not? But I'm taking two diversions. Probel and Propel is just too similar even you to claim the mark. Okay. Now the question is, if at all you want Probel, if at all, look to the goods and services what they are doing. Now just see the mistake they have done in this particular goods and services. Come to the second part, Propel device, which is already an objective. Just see business management, consultancy, administration, office function, personal services, wholesale retail in relation to education supplies. It means that this particular brand is only for education related purpose. In fact, above, if you see, you will not able to find just advertising this and this brand economic risk document in the field of business and planning journal. If you see both the mark is different in business purposes. Above, I am not able to find out if they are in education or not. Second one is more in an education. So now the question comes, if my mark is in a different sector, though it is the same class, 35, suppose if I am in a different sector, education, and they are in different sector, can I get this mark? Now, this is where smartly you need to reply first. Education falls under section 43, I think so, 41 or 43, 41 something. First point is you also have to register under 41 or 43. I think it's 41 education part, right? You should file under 41 for education and then 35. 35 should not be your priority when it comes to this particular business. It has to be 41 and then 35. But assuming you have not done 41, suppose for whatever reasons you may believe, I will still argue on this point that my application is related to the education business and there is very broad, nothing to do with my business. So definitely my argument in my reply will be that I don't fall under section 11 and there is no likelihood of confusion because my business education has a different marketing channels. It has nothing to do with what they are doing. What they are doing is totally different. And hence, my mark has to be registered. If I go with this belief, then I'm pretty much sure that I'm able to get the mark. So today, if you ask me whether your mark is good or not, I am saying yes. I have a very good chance of getting this mark. Simple. Nothing to argue on that point. So this is where objection comes into picture. Now, the way I reply to the objection reports are like this. First, I definitely go with the point that why you have objected. Okay? And then I come to the point, reasons why objection is invalid. Third, case laws which supports my view, my opinion. Fourth, this is what I do as an individual, that I discuss. What if my mark and his mark are same? What will happen and what will not happen? And fifth, I say that my mark has to be registered because I have complied with A, B, C and everything. And this is where my mark has to be registered and definitely I file my objection report. Now, I'm just coming with this part that how objection report is filed. I'm pretty much sure that everyone knows it. I'm just explaining once again. ipindia.gov.in में आप चले जाइए, just log in by your digital signature or user ID. You will find a separate column on examination. You don't have to pay any fee for filing the objection reply unless and until that objection comes with the filing of TMM saying that you have not filed the proper readable POA. You need to file different documents to prove it. If that is the case, then definitely you have to pay the fees of 900 or something else, whatever. Okay, so this is where your objection comes into picture, and the moment you reply, your objection goes out. And then definitely the procedure is that once you file an objection, the hearing comes into picture. Now what today definitely we have a faceless hearings, faceless hearings chal raha hai, which is very good. So if you are able to do that, faceless hearings mein, then definitely you will appear and you will you'll just figure out what to argue and not to argue, but definitely your reply becomes the base. Okay. I will prefer that your reply has to be in a manner, as I told earlier, that your reply should reach out with an aim that if this matter has to go till Supreme Court, my logic and my base on which I am able to procure this mark or I am able to bifurcate, it has to be very clear the day when I'm filing the trademark, and then all the process of yours becomes very easy. Most of the times I have seen is that you file for the mark, or rather than say we file for the mark, and then we create the strategies, which is not possible, just not possible. Your strategy from the very first day has to be okay. I have taken out the search. These are the marks which I feel okay, objection may come or not come. Definitely you go for the mark where objection doesn't come. But if you feel so okay, objection aane wala hai, then go for that particular mark. But just see to it that your objections are very much placed on record from the day you file the mark. ठीक है, and then definitely you file it and आपका hearing हो जाता है and आपका जो भी order आएगा वो आएगा. Suppose if the order is refused, then definitely you need to file an appeal and then get it marked, which is a very, no doubt, it's a very costly affair. But then end of the day, it's all about how what is the importance of the mark in your business. I'm just closing this particular chapter on the objections part. Definitely I'll come with the reply. Now I'm coming with the oppositions. Oppositions part. Now, what is opposition in short? Now, होता ऐसा है that if you are able to clear your objections, then you have to wait for the advertisement, which is there for 4 months. Anyone, if they feel so for whatever reasons, they may object your mark. If anyone else trademark office objects the mark, it falls under opposition. So definitely they will file the opposition, you will file your reply. I will tell the procedure, and then opposition comes into picture. In brief, I'm sharing what is the procedure is that, suppose if the opposition comes into picture, they will file the opposition, then the notice will be sent to you. You need to file your counter statement within 2 months. You need to remember there is no extension under this trademark law. There is no delay control. You just have to be very clear on that part. Okay, and definitely then what do you call evidence? You need to file an evidence within 1 month. The moment you file an evidence, hearing will take place. If everything is okay, order will be passed. Just remember, opposition is nothing but an objection. The only difference is objection is taken by the TM office. Opposition is done by other than TM office. Simple. So your reply has to be exactly the same what you thought in an objection and then opposition. And anybody can object. I don't want to keep on object karega, because end of the day, a trademark is a very marketplace. If anyone feels that I was not able to comply with that procedure, they will come and they will do that. But how to reply to the opposition becomes more important. I'm taking 2 scenarios where I'm assuming that you must have taken care already when you filed the mark, or you replied to the objection. If that is the case, the mindset is very clear what you need to reply, and definitely you will reply. Again, the same procedure you apply. First, put out your facts. Why you filed the reply? Why you filed the mark. Who are your customers? What business you have done from the date of filing till the date of opposition? Why you feel that your mark is very innovative or there is no likelihood? So put out your facts first, and then reply their para to para reply. So normally what we do in courts, written statement may go for it, because end of the day, your reply has to be very in detail. It is similar to a tribunal, just go for it. In regard to para 1 of their notice of opposition, definitely the applicant denies whatever they have stated. In fact, the real fact is ABCD. Put out this thing. The moment you complete your reply as a denial to their opposition, earlier you said the facts and the reasons why you are good. Now you are replying with the denial with the proof. Then you come to the point that what is the reason? What is the reason that your mark has to be registered and their mark doesn't fall under trademark law? You can do that. That is your way of putting, and then definitely the prayer will come into picture. The one basic thing, I will say that I have seen in most of the opposition, I don't know, we rely on the POA. I'm not saying you should not rely that, since POA has been given, it will be signed. But I will suggest that if you file for any body incorporate, please go with the board solution. because you need to comply with at least the company law that any man who is who is signing on behalf of an entity has to be properly authorized. Because in most of the opposition I am seeing, whatever I have got is that there are no board resolutions authorization for someone who is filing. I'm not saying it is so much of mandatory, but definitely it is one of the argument point also that कौन file कर रहा है, who his position is and who is filing. End of the day, trademark is all about your business priority. You cannot miss out the chance on your business. ठीक है? अब तक whatever I have told for the businesses who really genuinely want their innovative mark to come in the market. So for me, these are the primary market business entrepreneurs. There are secondary business. They don't believe in all these things. उनका एक ही फंडा है. सेम नाम लो, फाइल करो, नोटिस आ जाएगा, नाम चेंज करो. So whatever I said to them definitely is not applicable to them, because they only believe that they have a business of around interim part. इतना काम कर लिया, नोटिस आएगा, सॉरी बोल दिया, आगे बढ़ो. So there's a different class of consumers. I'm not saying they are bad or wrong. Businesses are like this only: primary, secondary, third, fourth. It's all about how you consult them or how they feel to get this. So nothing to do with law. ये चलते रहता है. Especially you will find in pharma. There are many same packing, same logo and everything, and nobody wants to go to the court every time, because I can just say that in one of the matter in trademark, the ad interim has been extended to more than 2.5 years. Ad interim. Interim order has not even passed. So by this time, if I'm an opposite party, I have already done my business. But if I'm the first part, just imagine what is going on. It works vice versa also. Suppose if the complainant just had, just wanted to teach a lesson, he has filed 2.5 years. If he is able to extend ad interim, he has already, harassed someone, and opposite party is in a very big problem. So nobody wants to go to the court. It's a different question. So this is where the opposition comes into picture, and this is where you need to file your opposition. TMO करके form आता है. You can go to the website. Well, trust me, trademark website is one of the best website when it comes to any government organization. It just works smoothly. I have to say, I have used MCA very well in my younger days. I will say it's far better than trademark का website is far better. So वहाँ पे TMO करके आएगा. TMO में ही आपका counter statement and evidence file होता है. Just go with it, file it. Now I have just completed TM. I have just completed the procedure. I have completed the objection. I have completed the opposition. Now I just want to discuss certain case laws. And if anyone, before I start this particular aspect, if anyone have any question, I will be more happy to reply to you. And then I will come. I need to ask everyone what exactly your view is for certain marks. So I'm just pausing for some time for 1 or 2 minutes. If anyone has any query, please ask.
So there's a question: how did Organic India then get the registered trademark?
Just see to it under what they have filed. Okay, I understand your query is very genuine and good. How it has filed? First reply. I have seen is that there are 4-5 trademark offices in Chennai, Calcutta, Bombay, and Delhi. I have realized that if you're not able to get the mark in one trademark, the people are filing in another trademark office based on their preference. And the best example is, I will go for the Bewakoof. Bewakoof for somehow was not able to get the mark in Bombay. So they filed in South, they got it. You know why? Because in South, Bewakoof has no meaning. It is not a common word used there. Just can you imagine, there was a mark which was registered, PCOD. I was taken back when I saw this. There was a mark PCOD which was registered, if I'm not wrong, the owner is from Assam. The reason I was shocked is because PCOD is a direct connection to health issues or whatever. I don't want to use that word. It has a different meaning. But it already got the mark. Another mark which I feel should not have got is detox. I think detox is a registered mark of some company in a tea industry. Now that tea, the ingredients of that tea is that if you drink that tea, it will detoxify you. I mean to say, your brand is detox. And if I'm drinking it, it's detoxifying me. So detoxifying is an agent. I mean to say, even if I use the word in a tagline that Lalit tea detox, I should not be barred because detox is a detoxifying agent. Somehow it got marked. रही बात organic का, I just need to understand why they got it. They might have taken as a label or word per se, or logo. But yes, Organic India, if they were able to see India, they have not got the ownership. I'm pretty much sure. Organic India, if they are able to get the ownership, then claim that they are not the owner. And the best example I'll tell you what is happening is when we go for when we search the mark, and if you feel कि ये mark already मिल गया है, find out how they got the mark. I'll tell you the best khajur wala story. There was a date, Kimia dates, Kimia. ठीक है? So one of the man, he got this mark registered for dates. What happened is another businessman, कीमिया is something, खजूर होता है जो ईरान इराक से लेकर आते हैं, something from Saudi countries. वहां पे one type of a खजूर is called कीमिया. ठीक है? And one of our known client, they filed for the mark limia, and some used Kimia as a tagline. They got the notice, and owner of the Kimia, he filed the case before the Honorable Bombay High Court. They lost the matter saying that how can you get Kimia? My question is, if you see getting the mark registered, definitely is an admin part. So there might be some error. There may be some mistake. I'm not saying they will do it purposely. It happens. But if you genuinely feel that this mark should not have been got, you file for what you call, you go with that part. Definitely you can't go for the rectification, but at least you can file an appeal that how they got the mark. There was a mark by the name of World Directors World Class something, and there was already a mark by the name of Directors World thing. The owner, they said ki, I'm the first person to use this mark. They filed the case, they lost them. So Organic India, if you ask me, definitely they should have not got this mark. But if nobody is objecting, if nobody is going to the court, then they will come. But yes, you can. You have a good case at least to go there and satisfy the court that Organic India is related to something revolution, like organic revolution in India. So the mark should not be get. But yes, if they must have filed as a logo or a label, they will get it. There is no debate on that because they have distinguished themselves from that particular one.
Okay, sir. So next question, isn't Khadi also a generic name? So how was Khadi Bhandar registered?
Khadi, if you remember, Khadi was a registered mark by Germany also. They said कि हमारा market definitely for whatever reasons we were not able to protect that mark. So Khadi Bandar आना नहीं चाहिए था. Today also Khadi Bandar है, but Khadi Bandar, just correct me if it's a government organization. According to me, it's a government organization something. If it is a government organization, the rules are different. But definitely, if you feel that you are in the khadi business, then definitely you can use the same name, Khadi Bandar. But again, I'm telling you, sometimes you need to see the mark as whole, not one. The day if you are able to bifurcate कि खादी और भंडार अलग अलग है, तो ऐसा कोई मार्क ही नहीं बचा मार्केट में, because every mark कितना क्रिएटिव करोगे आप. इन फार्मा में एंड ऑफ द डे यू विल टेक द मार्क जो आपका प्रोप्राइटरी बताता है, इट कम्स फ्रॉम योर मॉलिक्यूल. आप कितना ही नया करोगे, बट यस, if you are able to identify, you are able to bifurcate by two different words, then it becomes a good mark.
Okay, sir. So next question, who has ownership over Darjeeling tea? Is it the state government or some association?
If there is an association, then definitely the association has a right, but definitely Darjeeling tea is equivalent to Kolhapuri chappal. ठीक है? And nowadays, recently we saw what happened with Kolhapuri chappal and Prada. If end of the day, I don't know if there was a PIL filed before the Honorable Bombay High Court. I don't know how we will able to stop Prada selling in their own country unless and until we are able to protect. Darjeeling tea, according to me, it has to be owned by the organization which is sponsored by the state. If it is privately owned, then definitely you have a good case to fight it out. Because Darjeeling is a word, geographical indication, and definitely it falls under that part. So you cannot use the name of a state or city name for you. Darjeeling is a very big place, so you have a good chances to even fight it out.
Okay, sir.
Now, what I want is that if anyone has any issue, I just want to ask something. so that everyone can understand. I am asking whether, whether Operation Sindoor, which is recently is in market, as a news, whether Operation Sindoor can be registered or not. If anyone, I want anyone saying anything. I mean to say, it has to be whatever. End of the day, trademark is all about that particular thing. जहाँ पे आपको लगता है कि I have an answer to this mark. Anyone, if anyone has an answer, because I personally feel that Operation Sindoor can be trademark. It has nothing to do with your emotions and everything.
Sir, since it is a governmental word, I doubt whether it can be registered.
But they never registered for the commerce point. They only went for some great things to be done. No doubt, we respect and appreciate. But the moment I come from the commercialization point of view, I mean to say, I am surprised to see that on what ground, I can anyone can say कि Operation Sindoor आपको नहीं मिलेगा, because it is not a mark which is falling under emblems and national act. I mean to say, they have not done that unless and until they have filed. That's a different thing. But I am yet to understand why. There's a different thing that someone, I mean to say, one of the company has withdrawn the mark. That's a different thing. But the reason why they have withdrawn has nothing to do with the law. They went with the public emotions. ऐसा है. So anyone, under what provision they must have gone कि नहीं आपको नहीं मिलेगा. It's my personal view. The reason why Operation Sindoor नहीं मिलना चाहिए is because many reasons is that Operation Sindoor has become very generic. It has become very common. So now nobody can use that mark for their own advantage because it has become already a well-known part. Everyone knows that. So as I said, section 9(1)(c) customary. सबको पता चल गया. So what is happening is that after that Operation Sindoor, whatever happened, anyone, whenever they say Operation Sindoor, they will directly relate to that particular incident, what has happened. I don't know, I'm sorry, I'm not saying incident. Great thing which has been done, right? So since there is an association to this particular mark, this mark should not be registered by anyone. That's end of the day, my interpretation why it should not be registered. Okay. But now I want to say, I want to ask, it's a very bad word, but since it's a part of the law, we have to use the mark. There was a brand name, as I told you when I started my lecture, that CHUTIYARAM. It was registered mark. Now, anyone can tell me why it was revoked, on what ground, and do you really feel it should be revoked? I feel it should not. It should not. It has nothing to do with religious part.
Sir, a participant is saying hurting the religious sentiments.
Okay, I'm yet to understand how, because if you are able to see from this fact that since there is a word used Ram, and if it starts affecting, then there is no word, then there can be no word which comes with this Ram. I mean to say, uh, I'm not saying Ram ye hai or Ram ye hai. I'm trying to say that earlier the surname were like this. If anyone visits Rajasthan in a very old area, rural area, this is one of the surname, if I'm not mistaken. There are certain surnames which are bad even to pronounce. So now the question comes, ki if it is my surname, if it is bad to pronounce, can my surname should not be used as a brand for my business, because I have not done anything wrong if my surname comes out as a gali to others? And what ground? I'm trying to understand. I mean to say, there are surnames, I don't want to say, but there are surnames which is not good when we say, when we speak. But then they are used in Aadhaar card, they are used when someone is called upon. So what is the problem if I'm able to get this mark? Forget about public emotions. I don't want to get that part. Religious, I understand, but three word which was a part of the one word should not create a religious part. ऐसे तो there will be no mark then. I mean to say everybody will try to say कि नहीं ये mark में तीन word मेरा नाम, जैसे हल्दीराम, उसमें भी आ गए तीन word, nothing to do with haldi, you know. So there has to be some logic. I personally feel it should not be revoked. हाँ, if the argument is that it is hurting religious, then बेवकूफ भी नहीं मिलना चाहिए था, because the word which I used, it has a meaning stupid. I can say stupid, right? You can Google it. So बेवकूफ का मतलब idiot ही होता है. So if one mark is getting revoked, how other mark got registered? Because one mark got public emotions, other mark nobody saw coming. Or can I say that one mark which was filed was a small party and the one mark which was filed was a higher party? Just think on that part. Because end of the day, both has a meaning which is very common in North, and it is affecting both of us. Today, if I am, if I'm using that word to anyone who is sitting here, anyone will be offended. So this is my view, and views are very different. But I always feel that this could have been a good mark. I mean to say, nobody will buy, would have bought this business. Okay, whether Indian coffee house should be a good mark for registration. Suppose if I go for Indian coffee house, I just want to know anyone whether it's a good mark to register or not.
Sir, a participant is saying yes if owned by the Union of India.
Okay, but now I just I'm trying to understand how one party, even if it is a union part of India, how they can say कि they are the only company who can use Indian coffee house. I mean to say, Indian तो ठीक है हर जगह है. Coffee is something very common. You have not taken the business of you are the only you. It cannot come to this point. We are the only company who can sell the coffee. No, I can use like suppose if I am using a brand Lalit Coffee, I will say it's an Indian coffee house. Nobody can stop me because at the end of the day there are no rights coming on that mark. For me, that is not a good mark. That is not a good mark because you should not get this mark. So the reason I am saying there is a case, Bharatiya coffee workers versus Indian coffee workers, if 1998 ka, where the court have rejected the society's plea, saying that they do not have the exclusive rights because your mark has to be in such a way that other cannot use it, and it should not be generic. India is a very generic. I mean, nobody can stop me from using the word India. Simple. Even if you file for a name in ROC, company, if you use some name, your authorized capital ka court fee is minimum. You cannot, go with the minimum authorized capital of 1 lakh. You have to increase your authorized capital. So same logic applies here actually if you go by that way. Okay, I just want to ask onus, ON, ounce. Ounce, is it a good mark for registration or not? According to any one of them, ounce. Then I'll just ask the questions then. Ounce is one of the measurement ticks. So anyone can reply if they feel that yes, this mark should have been registered. Then I will say कि जितना भी marks मैंने बोला है, how this can be registered in your favor. How? You just need to change the track. That's it.
Sir, 2 participants have said yes without any reason.
ठीक है. Yeah, if they are here, I don't mind if they come and speak why. So at least even I will know and everyone will know.
Yes, sir. Participants, please directly interact. Let's be quick. It's okay if you all are wrong.
Nana, everybody is right. In law, everyone is right. It's all about interpretation. So in Agams, in Ved, we say that कोई सत्य सत्य नहीं होता है. Every satya has 7 different truth. So that's why there is a word shayad. When you should always use shayad in every such because you are not sure whether it's true or not. Anyone wants to say anything, please? Okay, ounce definitely is a measurement, and any measurement which is common should not get the mark. But the reason you will get the mark is the way you are able to put your mark in your business in a different way. Like अगर आपने अपने प्रोडक्ट में ओनस को ऐसे लिख दिया, ओनस इन यूनिट्स आपको नहीं मिलेगा. अगर आपने ऐसे if you are able to put the mark onus, super quality or whatever, you will get the mark. So now this is what I was trying to say, that when you file for the mark, your objection reply should be ready on that particular date because you can expect the objection on certain marks which you feel is already there on record or you feel it may fall under measurement or phenomena. And definitely the way you reply is the way you are able to tell them the story ki why this mark is good for me. There are many marks which if you go through, you will be surprised how they got it. How Naukri.com got the mark. I mean to see, I'm still surprised, but they got it because they were the person who induced the story by saying that though it is very common, we have made it more popular among that particular market where it was never there in an aggregate way. So they got the mark. So end of the day, I just conclude on saying that your objection reply should not be the first step when you file. The day you search the mark, and definitely, this one more suggestion, I can give only suggestion that Suppose if you carry out the search on 3rd July, and if you're filing the mark on 5th July, don't do that. The day you are filing the mark, if possible, carry the search again on 5th July at 11 o'clock, and then you file at 11:30. Because ये जो आधे घंटे का गैप होता है और 2 दिन का गैप होता है ना, it changes all scenarios. So don't expect कि जो आपने search 3 जुलाई को किया था, it will not be updated on the 5th July. It might happen that by the time you file, someone has already filed. Because mind is a space, everybody has a mind. There are very like and unlike minds. So you never know you will get the same mark or not. So suggestion will be do that way, and your objection reply definitely has to understand the way it works. I'm just concluding this part. If anyone has any query, please ask me anything. I mean to say IPR related or whatever, I'm leaving it to you.
Yes, Shyam Talavadekar is my name. Aditya Birla, like my name or your name, Aditya Birla is a name. Can you comment on it? Were there any objections raised when it was getting registered, or how it was tackled? Thank you.
Okay. What has happened, I'll tell you what has happened right now. We're in 2025. So I will tell you the changes what has been done. In 2000, the trademark office, they were not so very particular on something or everything. Like today, if you file any application, you need to give a very specific business purpose. Okay? Like class 35 says advertising, business management, etc. Today, if you file any application and you put the same thing, they will object saying that you be very specific about what business you want. But you go back to 2000, 2001, 2, they were not specific. You do it and they will give it. So with times, many things have changed. Many things have changed. Even if you ask me, Aditya Birla today has become well-known mark. So they fall into the category of well-known mark. And even if your name is Aditya Birla, they may not allow you unless and until you fight it on a very different aspect that I need to use my name and surname. But I'm pretty much sure they will fall under well-known name mark, and you will not get the mark. So I'm pretty much sure when they must have filed it, they must have not got this objection so much. I'm pretty much sure. But yes, today if I'm filing it, suppose if my name is Aditya Birla, they will object me saying that your name, no doubt we appreciate under the law, you can use the name, but they have got the first name. But personally, I feel that I should be allowed to use the mark. But what will happen is, suppose if you use the mark, then the restriction comes into picture that what business you will bring. Suppose if I enter into Aditya Birla Garments, then definitely trademark comes into picture that now you're selling the, product, goods by having the same keyword what they are having. Because nowadays what is happening is that if you put Aditya Birla on Google keyword, their name will come. So there is a system where you are not allowed to earn from their keyword to your business. So definitely, but I'm sure when they must have filed, objections would have not come. It's like this. Things have
Can there be an objection if I file, let us say, for my name or your name you file? Can I give a precedence of Aditya Birla and ask for this as a trademark?
You should actually, because there are in Jain, there are certain businesses who have taken the similar names. If you go to any jewelry shop, they have got the similar names. So definitely you can take as a precedent, and end of the day, it's all about who fight. If you fight, you will get it. If you don't fight, you will not get it. As simple as
Who
that.
filed first, you mean? Who filed first?
No, suppose if you want to file, you file it. Suppose if I want, I'll go with it. I suppose today, if I'm starting my business by the name, whatever it may be, something which is my sir, if my name would have been Aditya Birla for whatever, and if I wanted to start Aditya Birla Jewelers, I would have filed by the name, said that but this is my name and I want. If they don't apply, I will start the business by the same name, sole proprietorship or partnership firm. Nobody can stop me. But this is where the law comes into picture.
Let's say my name also is Lalit Jain, your name is Lalit Jain, and you got it like Aditya Birla, you got the trademark. Now I can also apply with Lalit dash Jain and then say that I am also Lalit Jain and I want Lalit dash Jain. Although to you Lalit Jain is given without dash. Can it happen?
See, it will not happen so easily unless and until you are able to identify my democratic or geographical where I am working and what business you are doing. Suppose if I am in an ice cream business and you are planning to do a tile business, you will get the mark. Suppose if you are coming in the ice cream business, same like me, then I will object. But then there is an option of saying that आपका नाम भले ही है, then I have to prove that I am a well-known mark. So responsibility again comes on me rather than you, that I have to prove I am a well-known mark. If I am able to prove my well-known mark, then definitely you will have a very hard chance to get the mark. Law says that name and the surname should not be the it should be allowed to use it. But by the time we are in this particular field, it is getting little bit practical and difficult even to use the same name. Yes.
Right. The 6E, Indigo and Mahindra. Something similar, right? That's what had happened.
Yeah, they filed for the electric part, and Mahindra and Indigo said that, boss, we are already in this business. And they, on the very second day, they withdraw it, saying that we are in the discussion of negotiation, but we all know that there is nothing called negotiation. Even they realize that they will hit it very hardly because they are already in that business, so they cannot use this name, 6A.
If I mistake not, for academic purpose, I'm asking, if I mistake not, they are still on it. They have just withdrawn for the time being, and
Yeah.
it is being fought. And
Yes.
I think it should be fought because they're in different business. Like you said, Lalit Jain is in legal business, and I'm in, let us say, masala business. So I should still fight. I mean, 6E, they should still get it academically because they're in car business.
No. What has happened is that first of all, they are a well-known mark. They have claimed it. But second, they have already. I think, if I'm not mistaken, they are already in the electric part, in the automobile sector.
Yes, they are.
Definitely, the case is going on. But see, in IPR, what happens? The day if you're not able to get the interim relief, suit becomes a very regular routine, and nobody waits for the suit. So, if you ask me, I am pretty much sure that they will change the name, because they will not go with the same name. End of the day, Indigo has a very good chance because they are in the automobile and they have a very known mark. Today, if you ask anyone, Indigo 6, it's a very well-known mark. And I'm pretty much sure they must have applied for that mark.
Yes. Thank you. Yeah.
Interpretations is all about, trademark is all about different perceptions. There is no one answer to it. Situation based answer aata hai. And the best example, Whirlpool wala judgment and Cadilla, it just created the whole scenario in a very different way.
Right. Thank you very much.
Sir,
Please.
this is regarding that Texmati and Basmati. Texmati is of American origin,
Yes.
and Basmati is Indian origin of rice. So there was a kind of a court litigation on this. So what was the outcome of it like? Who has taken the mark?
End of the day, Basmati will rule because they also come under GI and everything. According to me, Basmati, Texmati has not even come to India. They are not doing the business according to me. And
Right.
it's like this. Now the current thing which has happened about Kolhapuri Chappal, it gives us some lessons to as a nation, to us also, that you might have in your India, but you need to show to the world. Now what is happening?
Right.
We are not able to show to the world what we are capable of. Okay? So what they do, they come here and they, Basmati ka Texmati kaise hua, it is a very good point. They come with the seed. They took the seed from us during the training.
Right.
Went there and they grown up the Texmati. I mean, now, if there's a different thing, that Basmati is a very world known, it's a very ancient part. Okay?
Yes, sir.
Now, if you come to law, how to protect? Unless and until if you don't file in other parts through Madrid Protocol, you need to do that. Today, if Prada, if we are able to sell the Kolhapuri Chappal by their own names, you can just imagine that we are not protecting our IPR in a very solid manner. Else, there was no way they could have got this. But it was our mistake in Basmati case that they got the seed, and without our protection, I think, if I'm not mistaken, Texmati, they got the protection in US. It was like this, if I'm not mistaken. So, but if you ask me, they cannot enter India. And definitely, the same case happened with the neem part, neem, haldi, if I'm not mistaken. So, some of them, they claimed that, and they stopped it, saying that ki neem hamare yahan se hazaron saal se ho raha hai. So, but see, it's all about our protecting. End of the day, laws are made in such a way that you need to protect in each and every country nowadays. There is no concept of well-known all over India, world, by the way.
Yes, sir. Thank you for the wonderful answer.
Thank you. Thanks.
Okay, thank you, ma'am. Anuja, ma'am.
So there's a brand named Garguti Food Products, and it's been registered under class 30 and 35. It's for manufacturing of flours, like
Of manufacturing of?
manufacturing of flours, atta.
Okay, atta. Okay.
Konkani flours.
Okay.
So, Garguti, a word being quite a common word. I have a query that like many of the local brands, they use Garguti this, Garguti that. So, are we supposed to object on the same?
If you are the owner, you can see, is it affecting your business or it will add your business?
Okay. It was a pickle. It won't affect our business.
Nee, I'm saying suppose if you have a plan to go in a pickle business or their business,
No,
what
no,
I'm
we are
trying I'm trying to say ki whether
Huh.
using that word will make you benefit or not.
like we are not looking forward to go into pickle business. So that business won't affect us, but still they are using our word. So we have to object or we have to stay quiet.
You cannot object. You can just make an issue or opposition up karo, third party opposition saying that this mark cannot be registered because it's a very generic name. You can do that in opposition stage.
Okay, third party objection. Okay.
Third party opposition. Objection is always done by TM office. Opposition is done by
Okay.
other than TM officers.
Okay. So
जैसे
it can be
गर्भवती
basically just a opposition.
गर्भवती is very common. I mean to say उसको मिलना तो नहीं चाहिए, but लोगों में और डिवाइस में किया रहेगा in a different way, font size अलग होगा तो they might claim the mark, but they will only claim as a logo. They cannot claim the word per se. So
So probably because it's Konkan region and Gharguti is a Indian Hindi word, right?
it's a very common. Even we use it in our it's
But
not about Kolhapur or Goa. It's all about North, if you ask me. Who are in
Right,
rural areas.
right. So, sir, one more question I have is, so we should go for copyright registration.
Copyright होता ही नहीं है trademark का. That's a very, see, I'll tell you again, since you raised this query, I have been seeing that what many of agents or lawyers, or I don't know, but many of them, what they are doing, they are filing copyright for the logos and device. I don't know for what. Because if you see section 45 also, if I'm not mistaken, of copyright, if you use any mark for commercial, you need to take the NOC from the trademark office.
Okay.
In any case, once you have to take the NOC and then you need to file the copyright. Now, this is the loophole, you can say, what most of the people are doing when they don't able to get the mark, that they take the NOC and then they go and file as a copyright. But this will not help you in any way, because end of the day, the moment you do in a commercial part, trademark will come into picture.
Right. Yes.
Copyright is not a good suggestion. Copyright is good only when you are an artist or author and everything. Copyright, but
There's a company logo, sir. So how
company
do I
logo
protect that?
trademark होता है company logo. Logo, device, 3D, whatever sound, everything is trademark. Copyright has nothing to do with this when it comes to the commercial part. मतलब in a business, commercial business.
Okay, sir. Okay, thank you so much.
Thank you.
Hello. Am I
Yes.
audible, sir?
Please.
Yes.
Sir, as far as the use of surnames is concerned, so there was one case of this Agarwal Bikaneri Bhujiawala versus Bikaneri Bhujiawala, because Bikaneri Bhujiawala is a geographical indication like say Banarasi Sari. So it is used by say people who sell namkeen from Bikaner. And then the court allowed that Agarwal Bhujiawala can be used, but he can't use the word Bikaneri because he does not belong to Bikaner. And even there is now another Bhujia, that is Bikano. So they have changed or distorted the spelling of Bikaner, right? Because now say there is no restriction of geographical indication. So like that way they can use. So the test that the courts generally use is whether a customer, ordinary customer would get is likely to get cheated or not. Like in case of Parle G, somebody had changed the spelling, and Parel G, it was but Parel G. So the I think that matter went to Bombay High Court. They held that when this is a customer is likely to get cheated, and similar type of boy on that Parle G biscuit was made, and they said you can't use the Parel G because it is people are in rural areas can't distinguish between those spellings, and although the spellings are different, the customer is likely to get cheated, and therefore we can't allow this type of use. Thank you, sir.
Okay, in this, I just want to say that trademark is not about precedents which we rely upon. Trademark is all about the current situation, what it is at present, and the trademark can be interpreted in many manner, because as you said, I think there was a case of Starbucks versus Sardar Books something coffee house. And Starbucks, they went to the court saying that कि यार ये हमारा ही नाम use कर रहे हैं, and their argument was कि हम तो सरदार है, सरदार Books is the surname, I'm just there doing it. तो court said कि ये काम करो, सरदार dash Books कर दो, Books something, ठीक है? So the court said कि don't use one word, Starbucks is one word, use a Sardar dash Books, and they got the mark. So end of the day, you know, when you go to the court, we must have read section 9 or 11. End of the day, trademark is all about interpreting in a manner which suits the market and which suits the parties. You know, parties, I mean to say public in area, because trust me, many of the brand, अब rural में जाते हो, they don't buy from the word. They say packing और वो लेते हैं. Even from the place where I, you know, when I was very young, I used to see there was a similar parking like Parle, and I used to buy that. Same coconut tel रहेगा. So whenever we go to market, coconut tel blue color का bottle आता है, बाजू में ही उसका duplicate नहीं बोलूंगा, another company है, same blue color and everything, by the name some Crocodile something. So, you know, if you see any judgments, they always see कि ये market कहाँ का है, किधर तक reach होता है, who are the customers, and then accordingly the you know case are decided. It is not that they stick to one precedent saying that नहीं ये हुआ है तो ये ही होगा. ना, trademark is all about changes every day, every time based on the situation.
Hello, sir. Sir, the basic thing we see in the market, the running products, right? Right now you said the oil example, the color similarity, the same things we see in each and every product which are running from toothpaste and all these things. So in India, these things are going on and many a times no one objects because it is a policy of earning and a business. But likewise, the question which is raised now of Pradha and Kolhapuri chappals, the style is totally copied, but they are claiming that it is their own production. They have not taken any manufacturing raw material from India. So here I want little bit clues that how it can be clarified whether India can claim them or they can be like that only the things as they are going on. Just a clarity.
Okay, कैसा है? See, what has happened recently actually may raises many important questions about India as a nation protecting its own IPR. And रही बात MNC's company का, let me tell you, if not today then tomorrow, there will be many names of products which will be trademarked by them unless and until we protect them. Since we are not doing it, anyone will do. And see, we are in the world of commercialization. And whoever gets the opportunity, they will do. I mean, they are a big company, they will do. Rahi baat, they are saying ki this is our falana falana. Even they know they have copied. They have not done anything new. But they know that nobody can touch us because they should have got the protection from where we are doing it. So they must have got this logic. They must have done their legal research. Okay, they have not protected. They have not done this work. So let me do this. So, you know, it's all about how we fight in the international market. That is the biggest issue now. But yes, what you are asking, I'm of the view that India as a nation shall ensure that whatever GI or old designs, whatever we have, it has to go to the international market. Unless and until we don't do this, we will lose the mark, the patent, the seeds and everything, the way we did in Basmati and Dexmati, you know. Though we might have won that matter in a very different way, but end of the day, we gave away our Basmati to someone without any protection. That was the biggest loss for us as an Indian.
Thank you, sir.
Sir, a participant is asking, last year he had applied for he or she had applied for a word mark, and till now they have not got a reply. So what is the general duration of examination?
No. See, this is a very long period. Normally, on an average, if you ask me, I'm covering all the states. On an average, you should get an update or reply within 2 months. Assuming 2 महीने में नहीं आया हुआ है, I will prefer you go and meet them and ask them what has happened, because it might have happened that they might have done, you know, something must have happened to them, because automatically word per se हो या कोई भी हो, updates they come by 2 months or 3 months. उससे ज़्यादा I am not able to see any delay. As on I'm seeing about as on date. So if it is 1 year, then please go and find out what has happened, and just go and meet them, or at least you can send an email. They will reply back to you, because I have seen that they also entertain over the call, by the way. So you can try that. But the normal time period, if you file updates, whatever is the update, you will get between 2 to 3 months. If there's an objection, and you need to reply within 1 month, if you reply, hearing comes somewhere around 3 to 4 months on an average. And then if there is no opposition, आपको certificate आ जाता है. So on and around 12 to 14 months along with the objections, unless and until they're very much with the loads of the work, which takes time. Opposition का तो I can't even say कितना time लगेगा, because there is no end to it. I am expecting at least by the end of the next year, they will come to the current position and they will do the work.
Okay, sir. So, sir, we can conclude the session.
Okay, thank you. Thanks.
Thank you so much, sir, for sharing your insights and illuminating us and patiently addressing all the queries. Thank you so much, sir, for the practical understanding.
Thanks, everyone. Bye.
Bye, sir.